Okay, can we start now? Mr. Subhash, are you ready? All right,
Yes, I am.
everyone, and welcome to our workshop on how to moot the art of oral submissions conducted by Mr. Subhash J. Devaraj. My name is Umasri Ravindran, and I will be your MC for today's event. Before that, can I just check whether my audio is clear? All right. Mooting is a vital skill for aspiring lawyers, and this workshop aims to equip you with the necessary tools and techniques to excel in the art of oral submissions. Mooting is more than just a simulated court proceeding, it is an opportunity for law students and young professionals to develop their advocacy skills. Throughout today's workshop, we have Mr. Subhash J, who will be sharing his knowledge, insights, and experiences to guide us on this journey. Remember that mooting is not about winning or losing, but about refining your skills and embracing the spirit of intellectual discourse. So during this session, Mr. Subhash will be going through the fundamentals of oral submission and provide practical tips on how to deliver your arguments effectively. At the end of this session, we will have a Q&A session where you can ask any questions you may have regarding the oral submissions. You can type your questions in the chat box or you can send it via WhatsApp and we will try our best to address all of them. Before we move on, I would like to introduce our speaker for today, Mr. Subhash J. Devaraj. Mr. Subhash holds a bachelor degree and is currently the Assistant Manager of Business Development at the Asian International Arbitration Center. Mr. Subhash is also actively involved in the international mooting community. He has served as a judge for prestigious competitions such as the International Jessup, such as the Philip C. Jessup International Law Moot Court Competition in 2022, where he presided over the preliminary and top 32 rounds in Australia. Additionally, he has contributed his expertise in the Jessup national rounds of Bulgaria and Belgium in the same year. In addition to that, Mr. Subhash J has also dedicated his time and skills to coaching and mentoring aspiring legal advocates. Recently, Mr. Subhash served as a coach for the champion team from Fields Asia College in the Philip C. Jessup International Law Mocha Competition Malaysian National Rounds. His coaching experience further demonstrates his commitment to nurturing the next generation of legal professionals. With his experience and insights gained from both academic and practical endeavors, Mr. Subhash brings a wealth of knowledge to our workshop on the art of oral submissions. His expertise in arbitration, business development, and legal advocacy makes him a valuable resource for understanding the intricacies of presenting compelling arguments and delivering persuasive oral submissions. So, without further ado, let's give a warm welcome to Mr. Subhash and get ready to learn some valuable insights on oral submissions.
Hi. Thank you very much for the introduction. Um, so I've been asked to actually speak about oral advocacy skills in light of the upcoming internal UNISA moot court competition. So I understand this is a competition among the students in UNISA itself, correct? Right. So just
We actually
a few things. So I've actually I started mooting when I was just after my A levels actually. So it was approximately 4 to 5 years of experience of mooting. And during that experience, there are many competitions that I've lost, a few that I've won, and then I've gone on to coaching, and then now judging. So during this experience, I would say one of the most attractive things about mooting that I found was the fact that you get to actually learn new areas of law that you don't necessarily get exposed to during your when you're studying for your law degree. So when I did the University of London program, there were very limited modules that I had to choose from. So we, for example, right, when we do it with a tertiary institute like ATC or BAC, a private institute, it is up to that institute on which subjects they want to offer. So we don't learn subjects like constitutional law or public international law, Constitutional law, for example, even University of London don't provide it. So the only exposure we get is through moot competitions like this, or if you have events by other student organizations like ALSA or ILSA for this matter, then that is the limited exposure we get. So that was interesting, the new areas of law that we got to explore through mooting, only because we don't learn them in the classroom. So some of the big competitions that y'all might want to keep a lookout for, which is very specific to the area of law that they test, would include competitions like Law Asia, where I think the recent one they're going to open up registration soon, or I'm not too sure if they've actually already done that, but that should be happening around August, around that time. So that competition is solely on arbitration. Like they do not test you in a court setting, right? So you learn you learn areas like conflict of laws, procedural law concerning arbitration, and that is sort of with Law Asia, and it's usually two private individuals. They're having a dispute, and they're usually from different countries. So they are real countries. It won't be fictitious countries. Like for example in Jessups, they'll be real countries. So you'll have to deal with foreign laws in that aspect. So when I did it last time, it was they call it the substantive law that's applicable. It was Nepal law, which we never had any exposure to. So that was interesting for us to research. Some other major competitions also in the arbitration field would include the VIS. So I did the pre-moot VIS, which essentially is AIAC's version of the VIS, where they have it like a training ground for all the international teams to come over. That's interesting because it's also in an arbitration setting, but the difference is that it involves state parties against investors, for example. So usually there is a slight touch of international law element there. So that was a new exposure. And then you have the international humanitarian law competitions, be it the Moot competition or the one that they have introduced in the past 3 4 years, the role play competition, that solely tests you on international humanitarian law, which is a subset of public international law. And then you have the big one like Jessups, which goes only on public international law, and the setting is the ICJ. Now, these features I think are quite important to take note of, only because you can actually see where your interest lies and then pick the competitions that you want to do. So you also have the local competitions like the KL Bar Lincoln's Inn Moot competition, which only concentrates on constitutional law, for example, right? And then you have other competitions like you have one, there's the Hussein on Moot competition, which also concentrates on corporate matters and a slight touch of constitutional law as well. So it's good to know which areas you find interesting or you have never heard of. There are competitions only based on intellectual property law, and then that will allow you to decide on whether you're going to enjoy it or not. So for me, the attractive feature about it was to actually learn about these new areas, and of course I really enjoyed working with my team. It was never a set team, so we always change team members, but there are a few that I um, commonly been teamed up with, because we had the coaches who would assign us to these roles, you see. So these are some of the attractive features I found in participating in moots, and therefore most of the time you'll hear it from my lecturers. So I was never a good student in class, only because I spent too much time in the moot court rather than actually being in class. So I was one of those type of students, and the reason for that is because of all these things that I found attractive in moot competitions. So yeah, my first advice would be to actually take a look around as to all the available competitions that y'all can join, and then instead of signing up for the first thing that comes up, also take a look at what the competition is about. I think that will give y'all a rough feel on whether y'all are going to like it or not. So now I'll come to the actual sort of focus into this internal moods that UNISA is doing, right? Which at a glance of the mood problem, it seems to be loosely based from the Jessup's format. So what we're dealing with is essentially a mood problem that concerns purely public international law, and you're before the ICJ. So the reason why I stress is before the ICJ is because it requires different sets of decorum, which is something that you all need to take note of. What I mean by this is, if, for example, you have a moot competition where the mooters are arguing before the Federal Court of Malaysia, then the way you address the judges would be very different. So you would either call a female judge my lady and male judge my lord, for instance, or you have some mooters actually, only because it's the Federal Court of Malaysia, right? Just calling them Young Arif. I think it's much easier because it's gender neutral. So it's easier so that you don't get confused, or you don't have to use too many different terms during the submissions proper. When it comes to arbitration, for example, you don't use these sort of terms. You call them Mr. Chairman, the presiding person, and then the remaining two judges, you call them Madam or Mr. Arbitrator. Now, for the ICJ, you usually address the bench, the judges, as your excellencies. So these kind of decorum is quite important, only because if you actually look at your scoring sheet, which is in the rules, right, you actually have an equal allocation of marks for style, grammar, and citation. So these sort of the way you address the bench and all would most probably go under style. So it does carry weightage. Now, if you look at the scoring sheet for other moot competitions, usually it's not equal allocation, but there are some that provides equal allocation. What I mean by equal allocation is you have 20, 20, 20, 20, for example. But for Law Asia, right, they have a separate segment for time, and that's given like 5 marks, if I'm not mistaken, 5 or 10. So they have different sorts of allocation. Law is given the highest knowledge of the law, which I think is about 40, if I'm not mistaken. So they have different allocations, but it really depends. Either ways, the way you address the bench is important. So these sort of information you usually get by looking at the moot competition itself, which gives you a lot of insights as to what should be done, right? So coming back to this internal moot competition, it's to do with the ICJ. So that automatically tells you that it's in a court setting. Other things that it gives you hints of are things like, when you address the judges, you usually stand and address. See, because of this whole COVID episode, right? A lot of the competitions have now been done online for some time now, for at least 2 years and a half. Last time when it was physical, this was actually very important to know whether it's in a court setting or an arbitration setting, only because in a court setting, you are actually required to stand at the podium and submit. But when it comes to an arbitration setting, you actually sit down in a round table with the judges and then you submit. So these sort of differences also plays a role. But now, since some of the competitions are online, these things are a bit more, I should say, gray. Because if you realize, right, when you look at competitions online through YouTube and all, certain competitions, they will have one screen where the whole team is before them, and then you have one speaker stand up. Certain competitions is just all the speakers are at different locations, and then they just sit down and submit. But just be careful when things go physical, because they are going physical now, that you want to take note of these sort of things. And the easiest way to get a hint or get a rough idea on what you're going to be up against is to actually look at the mood itself, right? So that's that in terms of what this mood competition in and of itself tells you. Now I'll get down to the rules. If you look at the rules, there seems to be, or there is actually, 4 speakers for the whole round, right? You have the first applicant, second applicant, and then you have the first respondent, second respondent. Of course, the mood rules for this competition refer to them as lead counsel and assisting counsel, if I'm not mistaken. So this is quite common. In the JASAP's competition proper, they don't call them counsel, they call them agents. So how do you know, right? Because you have all these different terms going around for different types of competition. Like Law Asia, you usually just say by name. You don't even call them as counsels. Very rarely you call them as counsels, only because it's slightly an informal setting. So the best indicator of what term to use to address your teammate, to address the judges, is to actually refer to the rules. Usually the rules will give you hints on how is it that you should carry yourself during the competition proper. So let me get down to the individual roles, right? I will just call them as A1 for applicant 1, A2 for applicant 2, and then R1, respondent 1, and R2 for respondent 2. And I will just briefly explain on the roles just for y'all to get a rough idea on what are y'all expected to do if y'all are playing that particular role for that round. So for the first applicant, the the first thing that you're required to do is to introduce yourself as well as your teammate, and equally important is you're also expected to introduce your opponent. So this is usually done in the Malaysian courts as well. So if you all have done internships before and you all have seen a court hearing, especially appeal hearings and whatnot, even trial hearings, I say this happens. The person that usually starts the submission, so it's usually the claimant or the appellant, right? In the local courts, they would usually start off by introducing themselves and whichever counsels that are on their side, and then they will also introduce the opponent. So that is also done in moot competitions. You don't need to introduce them and their institute. Of course, here that's not applicable because everybody is from UNISA, but for national competitions or international competitions, you don't need to introduce where they are from. How you need to introduce them is to say their name and to say which party they are representing, right? So usually before the judges come in, the way it's done is you are expected to be at the room earlier. So JESSIPs, they are quite strict in the sense that you must be in at least 30 minutes before the round actually starts. Different competitions have different rules. Like Law Asia, it is also about 30 minutes. IHL, they don't really give you a time per se on when you must enter the round, but the way they work is they will have a bailiff there, which is a person who's part of the organizing committee who's supposed to maintain your time and all. So they might either have two students there, two students are helpers. One of them is a timekeeper, the other one is a bailiff, or they can have one person doing both the roles. So this person would usually wait until everybody is in the room, and then this person would call in the judges. Because the last thing you want is a panel of judges actually there and the mooters are not there yet, right? So it is this short period, right? This short gap in which the first speaker actually has to go and ask the opponents their names and all, their full names and all. And it's very important that the first speaker does not mess this up. The reason is because if the first speaker messes up the order, so for example, R1 is Miss A, R2 is Mr. B, right? And then the first applicant, when he or she starts off, mixes up both of them, swaps them. It creates a lot of problem because most of the time the judges whom will be scoring y'all will actually have to score y'all with the names there, right? So they will have columns in the score sheet, and for R1 you will actually have to write Miss A or Mr. B. So when the first speaker swaps them, right, and if the bailiff or timekeeper is not cautious enough, what will happen is the judges might get confused on who is actually representing who or who is playing which role. So that is why it's very important for the first applicant to get it correct. Only because you don't give the judges an extra worry to think about which party is representing which specific role, right? So I suggest always go in slightly earlier. You can always talk to the bailiff to see what are the names of the speakers playing that specific role, and get it down, right? So that's the first thing that you need to do. You need to introduce yourself, your teammate, as well as your opponents. And then the next thing you would want to do is some competitions, they would actually tell you each mooter is given 20 minutes, and then you can have 5 minutes for rebuttals or sir rebuttals, right? But most competitions, they will not do that. They will just say each team is given 40 minutes for their full submission, inclusive of rebuttals and sir rebuttals if you're the respondent. So this creates a problem because the timekeeper does not know how much time per mooter is to be allocated. The judges also will not know how much time is going to be taken for per mooter. And it's not usually a standard thing because some teams assume, right, that because there's only two issues, so I will take 20 minutes, my co-counsel will take 20 minutes. That's not necessarily the case. Even in terms of strategy, you might not want to allocate it that way. You might actually want to think about which point requires more time, and that council takes the most amount of time. So the most recent, when I coached the Jessup's team, it was not an equal allocation of time. Our first speaker got slightly more time, and our second speaker got 2 or 3 minutes lesser. So it varies according to the team and the type of strategy you want to take, because you feel that the team needs to spend more time on this particular point. There's more elements to prove. So this speaker gets allocated slightly a higher limit of time, right? But all this is too many variables for the judge to keep track of. So that is why the first speaker is also required, after introducing yourself, your teammate, and the opponents, to state your allocation and your teammates' allocation. You don't need to state the opponent's one, because the first respondent will do that. So what you would need to do is to state that I will be taking this amount of minutes for my submission. My co-counsel will be taking this amount of time for his or her submission, and then we reserve maybe 2 minutes or 5 minutes for rebuttals, right? So once you're done with the time allocation, then what you will need to do is, the sad fact of moot competition is most, I shouldn't say most, but rather there are situations where judges are actually not fully well versed with the moot problem. And the reason why this happens is not because these judges deliberately want to not put in the hard work, is because you have situations where competitions are organized, right? And the organizing committee books a particular person to be a judge 2 3 months in advance, and towards the last minute something goes wrong. Either the judge cannot make it for various other reasons, appointments or sick and whatnot. Then another person has to step in last minute. So in situations like this, right, and this can happen in in the most shortest time frame I can think of. There were situations, right, like I only had 20 minutes to prepare for a round, because so happened two judges pulled out, and then I was called to go in to judge a round. Most recently, it happened for the AIAC Vismut, only because I'm there in the office doing some other random work, and then one judge pulls out from the competition, and then I'm supposed to go in, and I've not touched the mood problem at all. So of course it creates a problem, because the judge, you will have situations like this where the judge is not aware of what are the issues and all. And of course, to the other end of the spectrum, you have a judge that really doesn't bother to read, only because the mood problem is too long and whatnot. So for the benefit of everyone, and to provide some clarity to the court, right, once you finish up the introduction, the time allocation, the next thing you would want to do is to point them to the page of the mood problem which states out the issue. So usually this is at the end of the mood problem. If the mood problem has appendix and attachments and all, it would be right before the appendix and attachments start. So if you realize, right, the pattern in mood competitions, the mood problem towards the end will say party A is arguing for this, party B is arguing for X, Y, Z. So that needs to be pointed out to the judge, because then the court is very clear. These are the issues that we're going to deal with, right? You don't need to explain the issues first. You just need to tell them how many issues are there, and what are those issues. In practice, what I've observed is this also happens only because the court does not hear one case a day, right? They have multiple files to go through in one day. So sometimes it's good for the judges to be informed on this is the case and this is the issues that we are going to deal with, especially for appeal matters. Because for trial, you have cross examination, and whatnot. So it's a full process. But when it comes to appeal proceedings or even seeking leave for appeal, right? Usually you will find yourself in a situation where the court hears multiple appeals at one go or at one day. And when I say one day, it's like morning before lunch. So it's just too many things going on, and it would really help them if you sort of tell them or point them these are the main issues to be dealt with for today's proceeding. So similarly, we do that in the moot competition as well. And usually the first speaker has to do it, because the first speaker is the one we usually say sets the tone for the whole round, right? Now, right after you you inform the court of the issues, then now you are faced with sort of a choice which depends on which moot competition you do. What is that choice is you can choose whether you want to give them a summary of the facts. Why does this depend on which moot competition you do? The reason is because there are certain competitions where you're not given 20 minutes to submit per mooter. For example, the KL bar, right? I remember we allocated it in such a way because the time frame was so short, it was 10 minutes per mooter and then 2 minutes for rebuttals. So, which means in 10 minutes, you cannot be using 1 minute for introduction and 2 minutes for to summarize the facts. It's just a waste of time. And the facts are really short for KL bar. It's only 2, 3 pages long, at least when I did it. Now I realize it goes on a bit longer, but it usually doesn't go above 10. So it's a set of facts that is very brief, so to speak, right? So there's really no need for a summary. But when you have a long mood problem like Jessup's or VIS or even Law Asia, usually they would provide a summary. But this also depends on where you're mooting. Because I realize when it comes to local competitions, right, usually the first speaker will provide a summary. But when it comes to international competitions, they never provide a summary. Only because they expect the judges to be of a certain level, to be well versed with the moot problem. So they don't, there's no need for the mooter to inform of the judge what is going on, right? So international rounds, right, you will never hear, or at least I've not heard, a mooter asking me if I require a summary of the facts because they expect me to know the facts in and out better than them, right? So different standards. So then you have a problem because you don't know whether the judge needs a summary or the judge does not need a summary. So the best thing would be to ask them. And that is what the first applicant or A1 would do. A1, right after pointing out what are the important issues to be dealt with, A1 will also ask the court if they require a summary of the facts. So if the court does require a summary of the facts, then you provide a summary of the whole facts. If the court does not require it, then it's fine. You can move on to your submissions proper. So a few things to keep in mind when you want to sort of phrase your summary, right? You don't need to tell them or you don't need to try to include as much information as you can. There's no need for that. Usually, your time allocation for summary, especially for a competition that's longer than maybe 20 pages, would be 1.5 minutes. You shouldn't take more than 2 minutes, or in fact, 2 minutes to just provide a summary of the facts because it's wasted time. You have limited time and you're expected to actually put forth your case, right? So these are considered the preliminary parts of your submission, which you don't want it to eat up too much of your allocated time. So 1.5 minutes should be good. And if you add it with your introduction, like introducing yourself and your teammates, your opponents, and then the points to be discussed, you're looking at maybe at least a solid 2 minutes, 2.5 minutes before you enter your submissions proper. So now you know that the summary of the facts cannot be very long because then it's counterproductive. It's not the summary anymore. And now you know that you are very limited on what you can say, right? So my advice is, from what I've observed at least, mooters tend to put in as much information as they can in the summary because they think they want to get it all out. But I don't think that's very strategic. And the reason for that is because when you deal with your individual issues or when your co-counsel deals with his or her respective issues, you are bound to repeat certain parts of the facts, right? So there's no point for the summary to go in depth into a particular point only for you to then repeat it during your submissions proper. It's a waste of time because you're just duplicating the work. So my advice is only highlight the key incidents. Like for example, Jessup's competition, even this competition, they will always give backgrounds on the party, background information, right? And sometimes you don't need to tell them the full background information, only the characteristics that are important. So how do you sieve out what is important and what is not important? I think the first step to do that is to approach it like like you're studying for an exam. So the way University of London students do it, and I say UL is because we don't have any practical aspects in our degree, which is one of the downsides in the UL program. I think it's purely exam based, so you strategize like that as well. There's nothing practical for us to do, which is bad, right? So because it's purely exam based, right, the way we study for it, or most students that I know study for it, is they will sit through class for a chapter, and then they won't read deeper into the chapter first. What they will do is they will open up the past year questions, because we have a list. It's like compiled for the 10 past years. What are all the questions that they have asked? We have all the exam papers that will be given to us. They will look at the past years, and they will spot all the time that the multiple times that particular chapter has come out, and then they will backtrack their work. So they'll say, okay, this chapter has 6 different things I need to study, but the questions only come on these 2 important areas, and then they will just focus on those areas, and then they'll go for the exam, and they'll do really well. So this is how I think it can be done, or it can be adopted into the summary of facts. So you straight go towards the end, and then you see what are the issues that are to be dealt with, right? And then you see what are the facts that concerns those issues. And once you extract those facts, then you know those facts must be in the summary, instead of going through the moot problem from start to finish and then picking out the important points. How would you know, right, which is important, which is not important? Only when you look at the issues that are going to be discussed will you know whether it's important or not. So my advice is work it from the back. And similarly, following this style, right, you don't need to start phrasing your summary as the first thing. What I mean is, when you get the mood problem, if you're already preparing your script, you don't need to start wording out your scripting your summary at the get go, only because you have not researched into the issues yet. So you don't know which part of the facts are important and which are not. So for this competition in particular, right, as well as the pre-mood Viz did not have this, but Jessups of course have it. You have the memorial. In the memorial itself, you would most probably have a portion where you're supposed to summarize it. So some mooters, they tend to just say that a summary of the facts can be found in this page of the applicant's memorial, and it's provided there. So that way they get rid of this problem. But there are competitions, for example, like Law Asia, right, where there's no memorial, and then the moot problem is long. So they do need a summary, and you have too many facts that might not really be relevant, and you sieve them out by looking at the issues. And you don't need to start on the summary the first thing. You can work on researching the points first, coming up with the remaining parts of your script, and then towards the middle or the end, you can word your summary. That is how I usually advise my mooters to do it as well. We have a very rough draft of the summary, and then we always change it towards the very end, only because our research has matured. You see, we have spent enough time with the issues, so we know which parts to stress on, and which we can sort of uh, keep it for either the submissions proper, or we don't need to raise it up. It's not really necessary for the judge to know. So that's one thing to think about. But the important thing to keep in mind, right, because you will, not to say get into trouble, but you might face an attack from the opponent if you do this. You must always keep the summary from a neutral perspective. Right. So for example, if you have a moot problem that says where it's an issue whether state A rightfully or lawfully, in other words, launched an attack against state B, in your summary, right, you cannot say things like, on this date was when state A unlawfully launched an attack. It's not unlawful yet, because that is what you're here to discuss. It's a contentious matter, right? It's not a settled matter. So it's not a neutral way of saying it. Now, if you put things this way, you may feel that you're trying to convince the judge at the get-go, because you're trying to word your summary of facts in such a way that it benefits your position. But the problem with that is some judges that actually know the facts in and out will catch you on this. And when they catch you on this, they would be upset because they would feel that you're distorting the facts a bit. You're trying to say something that's in your client's position, which is not really an agreed premise yet. It's up for dispute. So you don't want to be caught in that position. And even if the judges are not able to pick it up or it flies over them, R1 might actually pick it up. When he or she starts, right, they might say things like, in substance or in spirit, we agree with the summary of facts submitted earlier. However, we hope or we intend to point out, then they might say this. So you don't want to be put in that situation. The general rule is always word the summary in a neutral way and always highlight facts that both parties have agreed. If they have not agreed, you tell them they have not agreed. So you can tell your summary and you can say, the applicants allege this, the respondents allege this. So this way, the judges are confident that they are getting a neutral perspective on what's going on before they actually hear the arguments, right? So I think that is one rule that you shouldn't break when it comes to the summary of facts. So right, when you're done with the summary, what then you will end up doing is you will need to do this thing where what we call it in the mooting scene, at least flag posting. I don't know if any of y'all have heard this before, but it's really just a fancy name for informing the judges on what you're going to do. It's pretty much a roadmap. So usually you will tell them how many submissions you have, and then you would tell them how many arguments, and then within those arguments you have points. So you can look at it like somewhat like a pyramid structure. At the very top you have your submissions, and then per submission how many arguments you have, and then under the arguments you have your points. But if you tell the judges, for instance, right, I'll be handling issue 1, I have 2 submissions to make. Under my first submission I have 3 arguments. Under my first argument I got 2 points. See, it becomes complicated. Then it defeats the purpose because there's no really clear roadmap. So usually we don't need to flag post how many arguments and all first. We usually tell the judges, I'm going to be handling this issue. My co-agent will be handling the second issue. In handling the first issue, I have 2 submissions to make. First, this, second, this. So once you go into your first submission, then you can tell them, I have 3 points to be fulfilled, or 3 elements that needs to be fulfilled. Addressing the first element, then you immediately start. So although you need to paint them a roadmap, you don't need to be hyper specific, because then because they don't have a slide presentation to follow you, you see. It's more verbally what's going on. They're trying to keep track of what's going to be said in the next 10 to 15 minutes, right? So if you make it very detailed, it doesn't give them a good picture on what's going to happen. They will be confused, especially if you have a situation where they are not so familiar with the law. And usually competitions like Jessup's, Law Asia, or VIS, in fact IHL also, you might face a lot of judges that are not very familiar with the law, as opposed to competitions like KL Bar, where you have Malaysian law, right? Because bar certain exceptions like officers from the AG chambers, usually lawyers, Malaysian lawyers, they don't deal with international law on a daily basis, right? So that is why it's going to be very difficult when you say things right at the flag posting level. I have 3 criteria to fulfill, and then for each criteria I have 2 arguments. It becomes very confusing. So my advice is just keep it to how many arguments, first how many submissions you have, and then when you address those submissions, you can tell them, I have 3 things to say for this, or 4 things to say for this, right? So keep the flag posting part simple and very clear. Now comes a common problem that some mooters face as to how many submissions should they have. How is there such a thing as having too many submissions? I personally think there is such a thing as having too many submissions. If you have 20 minutes and you have, I'll give you all something realistic. If you all have, let's say, four submissions, I don't think it's going to be very good, because you're not going to actually, you're not even going to spend 5 minutes per submission if you think about it, because you're going to need time for your introduction. The first counsel is going to need time for the summary of facts and etc. And then, not to mention the questions from the judges, right? So I don't think four submission really makes sense. So then comes the question, how is it you decide how many submissions you should have? I think it's very important, and usually I notice a lot of mooters are not very clear on this. There's a distinction between what are submissions and what are arguments that you're taking. Very often you'll realize that people equate both of them. So let me give you an example, which I think it's quite simple because most of y'all would have learned about this, right? So let's say you have a simple mood problem that's to do with a contractual breach. Now you don't need to say that you have, so you are in a position where you need to show there was a contract and it was breached. So you have 2 points, or rather two issues to be dealt with. The mood problem first wants you as the claimant to show that there is a contract, and the second thing you need to do is you need to show that it has been breached. So the opponent or the respondent has also two issues to be dealt with. The first is they want to say that there is no contract, and second, they want to say in the event if there is a contract, it was not breached, right? So let's say the first claimant is going to handle the first issue, whether there is a contract. I do not think it's wise for the first claimant to have, let's say, four different submissions and say the first submission is there is an offer, second submission is there is an acceptance, third submission is there are no vitiating factors. You see, I just feel it's too many subsections. You're breaking it up too much. I would prefer something like first, the common elements of a contract, or rather, the basic elements of the contract has been fulfilled. That will be my first submission. Under my first submission, I can go on to talk about offer, acceptance. It was not an, there was no ITCLR, for example, right? And then my second submission could be there are no vitiating factors, or maybe there was no misrepresentation or fraud or etc, right? So it's good for you to see how you can divide up your issues. I don't think you should take a legal test and use each element as one separate submission, because then you'll be left with 5, 6 submissions to do within a short span of time. I think you should group them up together. And the benefit of grouping them up together, right, is because you'll realize that when it comes to competitions, sometimes judges are quite comfortable with certain points. Like in the contract example, right? Most of the time, these judges will might I foresee at least them being comfortable that there is a contract. Only because if there's no contract, then there's no point for them to go into the second issue, right? Unless there's something clearly wrong. So they would pretty much be okay with you handling maybe offer and acceptance very fast, but maybe they want to hear more whether there's vitiating factors, right? And this is the benefit if you group them up together, because when you group them up together, you can deal with them very quickly. You don't need to move on to a different submission every time you want to go into a different element. And when judges are comfortable with certain points, right, you can just move past them and just conclude up your first submission, right? So think about it in a sense that which saves you more time. If you have 3 submissions just on whether there's offer and acceptance, and the judge is really with you on that point, you lose 3 submissions. You don't need to submit already because the judge is pretty much agreeable with you. Then you're left with almost nothing else to say. But if you have one whole submission just to deal with the basic elements of a contract, and the second submission is something on, let's say, mitigating factors, the judge is very clear. Okay, there are 2 broad submissions, and under these submissions, these are what that's going to be discussed. I'm okay with the first submission, so I'm not going to ask the mooter to fully present the first submission. I think I want to concentrate on the second one, and you'll feel comfortable because there's a clear division that you have made. But if you break it up into too many smaller pieces, right, it's going to get confusing because you already have a lot of submissions to deal with, and then now you have to move on from one to the other. You know what I mean? So I think it's best to group them up, and then you will clearly have your submissions. So for me, right, there is no hard and fast rule to do it. But personally, for me, I think it should either be two or three submissions per mooter, because then you have, I think, enough time for you to go into each submission. So usually, my mooters, if I coach them or if I'm in a position to give them some sort of advice, I would usually ask them to keep it to two or three submissions. If they really have to, then four submissions, but that is very exceptional situations. Exceptional meaning that maybe you're faced with a situation, right, where you're in an area of law where it's not settled and you have two different tests by two different academicians, and you need to address both the tests because you're afraid if you address test A, the opponent is going to argue test B. So you want to be fully prepared as the applicant. You want to argue, look, I can win using test A, I can also win using test B. Then I think maybe you should have separate submissions for each test. You see what I mean? So try to keep it to two, especially for this competition, because from my very general reading of the problem, I think there's only two issues to be dealt with. So it's going to be one full issue per speaker. So I think two submissions would be really good, because then you have enough of time to really go into the specifics of that submission, right? And that's a tip on how you can strategize per submission. So, as far as the first speaker goes, once you have done with the flag posting, then you actually go on to your first submission. So, you have to be very clear, this is my first submission, and then these are my points, and then you argue out your points. Now, something interesting that happened this year, because we were given the opportunity to tune in live to this, what they call it, it's not an Instagram live thing, but it was some Instagram program now where they had like this link, and then if we go in, we could actually see some of the briefing sessions that were being done for the Jessup Smooter, right? So they had two experienced judges talk about certain aspects of oral advocacy. What I found very interesting was usually when we do it in Malaysia, like in a local setting, right, we will always advise mooters to be very clear on when you're moving on to your next submission. So, for example, if I flag post, I would say things like, Your Excellencies, I have two submissions to make today. My first submission is this, my second submission is this. As for my first submission, we are saying XXX, and then I will go into saying this concludes my first submission. If there are no further questions, I will now move on to my second submission. You will realize most mooters will do this, but during this briefing that we got, it wasn't really a briefing, it was more of like a meet and share session kind of thing. These judges were advising us to not really inform the judges during the competition that you're moving on from one point to the other. So I'm not really sure on whether I agree with this, but I'll just tell y'all what's their thinking, and then I'll leave it to y'all to weigh it out on what y'all feel should be done during the competition. So the reason why people usually say inform the judges, okay, I'm done with my first submission, I'm moving on to my second submission now, is to make sure the judges are very clear that this is the demarcation. Like, okay, this mooter is done with his or her first point, they're moving on to the second one. But for the international sort of meet and share session, right, they were of the opinion that when you inform the judge you're done with a point and you're moving on to the next point, it sort of subconsciously triggers them to ask you more questions, because they feel that oh, you think you're done with the first point and you want to move on to your second point. I still want to bring you back to your first point kind of thing. So they feel like when you use words like I'm done with my first submission, I'm going to move on to my second one, it sort of triggers more question from the panel. So they say, or their advice is more towards, yeah, provide them with a roadmap but you don't necessarily need to conclude your submission, your first submission, before moving on to your second one. You can seamlessly go into your second one by maybe using things like, um, and that was the final element. So we submit that it should be ruled in this way, as for this point, and then you go on to your second submission. You don't tell the judges, I'm done with my first submission. If there are no questions, I'm going on to the second one. So yeah, I think that makes sense. But the way I'm looking at it is, I think getting questions from the judges is a good thing. I don't think you should avoid it, only because it shows that you are actually getting their attention. And the other thing which I find personally very satisfying is because you spend a few months researching on these points, right? So you will have a lot of things that you would like to say, but at the very end, you will not say it because you feel it's not needed and there's a time limit. So the only opportunity to show the judges on all your hard work and the research time that you've put in is through the Q&A session, because there are certain answers, there are certain research points that you can only say out when they prompt you with a question, you see, only because you cannot put it in your main script since there's a time limit. So these are some of the reasons why I actually like questions. So for me, if it's a trigger, then it's a trigger. I mean, I would just take it, because only because I want those questions from the judges. And usually, if you're able to answer those questions, you get scored very high. And it works on the other way as well, which means if you don't answer them, you get scored very low. But if you're confident with your research, I don't see why you should avoid the questions. I think you should take them on. So for me, if I were to train a team today, and I would definitely make sure their research is on point. I would still stick by the whole traditional way of doing things. That is to say that I've concluded this submission and now moving on to the second one, because I don't think I would want them to avoid questions. But I see where the advice, like I said earlier, which we saw through those international judges that meet and share session, I see where their advice is coming from. Because when you talk about the Jessup's international rounds, right? It's no more like submissions and then Q&A. At the get-go, you're maybe given 2 minutes to just present and introduce everyone, and then the questions start barging in, right? So maybe in that kind of hostile situation where there's non-stop badgering from the judges, you might want to use tactics to slow down the question. But for me, as far as national mood competitions go, usually you don't have that kind of situations. Very rarely. Some judges do that, though. I would. So I wouldn't mind taking this kind of strategy to actually say I've concluded the first submission, I'm going on to the second. So that's pretty much the roadmap and how you deal with the submissions proper. I know I'm spending a lot of time on the A1. That's because I'm covering a lot of things that are applicable to the other roles as well. So now, since we have got a rough picture of the format, right? Let me just finish up on what the A1 has to do. So usually you finish up the speaker finishes up his or her submission, and then you will go on to say that this is the end, and this is essentially what we want, and then you would pass on the floor to your co-agent. Now, if you don't have time, it's really fine if you don't summarize, especially for competitions like the present one that you all are going to participate in, only because you all have the memorials, right? So towards the end, if you realize you don't have enough of time, you just point them to the prayer of relief and just say, for these reasons, we submit that point number 1 and 2 in the list of prayer of reliefs should be granted. Because 3 and 4, your co-agent will handle it. You don't need to summarize the whole case for everyone. A2 will do that for you, right? So in case if you really don't have time, you can just tell the judges, this is what, and therefore we pray that 1 and 2 is granted in our favor, and then you conclude and you pass it on to your co-agent. Now this is where the time factor comes in, because certain mood competitions are a bit weird. Sorry, let me just check. I have until what time to finish my presentation?
You have until 11:30 actually, so you can You have a lot of time.
11:30.
Yeah,
Okay.
but you can end early.
Okay.
All right.
Okay. So don't worry, I won't be taking up until 11:30. I don't think I've done much to say. So where was I? Right, time. So here there's a bit of an issue with time, and the reason is because certain competitions, they the organizers are in a tough position because they need to have the round finish at a certain time so that they can start the next round. If you don't have that rule, right, some judges will just continue dragging on the round, right, by asking questions and extending time, and this disrupts the whole itinerary, the list of rounds that are supposed to take place. And then you have the next round judges actually just waiting for the round to begin. The mooters don't have enough of break time in between rounds. So usually when you have organizers that are experienced in conducting moot competition, they would brief the judges like, look, at the end of the day, it has to finish during this time. You are only allowed to grant an extension of time, maybe 1 minute per team, to be fair. So, which means total 2 minutes extension, 1 minute extension for applicant, 1 minute extension for respondent, for example, right? So, the problem with this is the timekeeper, we are not sure on what instructions the timekeeper is given, because there are competitions when A1 takes an extra time, right? The timekeeper will write it down as, oh, the first speaker is supposed to take 20 minutes, second speaker is supposed to take 20 minutes, first speaker took 1 minute additional time. So first speaker 21 minutes, second speaker 20 minutes. That is good. So that's fine, because if you extend your time, then you're doing it on the judge's discretion. But then you have competitions, right, where the judge grants you an extra minute, but the timekeeper deducts that extra minute from your co-agent. And this is not the timekeeper going rogue. They are allowed to do that because the organizing committee would have told them that you should do this. Only because your whole team is allocated 40 minutes, you see. So if A1 takes 2 minutes extra, then the timekeeper takes it as, oh, okay, that means I'm going to minus 2 minutes from the second speaker. But the timekeeper won't communicate this. So what then happens is, because it happens during the round one, so you cannot blame the timekeeper in that sense also, because that person is making the decision on the spot, like how much to allocate and all, right? So what then will happen is the co-agent is going to stand up, or rather A2 is going to stand up and say, I'm going to take 20 minutes for this point, but in actuality the timekeeper has only allocated 18 minutes for that point. So what's going to happen is the second counsel is going to submit and realize the timekeeper is raising up the placards that he or she has maybe 1 minute left, when the impression that they got was they actually have 20 minutes. So just be careful on this. My advice is try not to exceed time. I would tell my mooters, and I would go so far as to say never exceed time. So if it ends abruptly, it ends abruptly. And you would know, you see. Even if phones are not allowed, right? What we used to do is we used to carry those cheap digital watches, like a Casio or whatnot. Not the actual Casio, like we would just buy some 15 ringgit watch somewhere that has a stopwatch function, and then we would use it. Because when you have a stopwatch function, first you might have a situation where the timekeeper just loses track of time because maybe they're just tired or they're doing something else. So you would actually be very confident because you're keeping time as well, and you would know when time is about to end, right? Because different competitions function differently. Like for Law Asia, it is usually a 20-minute allocation. So when you start, the timekeeper will raise a placard saying 20 minutes left, and then they'll count down 15 minutes, 10 minutes, 5 minutes, 3 minutes, 1 minute, 0. Some competitions, they don't do that. They don't count down per 5 minute. They will just show 20 minutes and then 1 minute, 0. And then you have the extreme ones, like this, for example. They will show 20 minutes and then they'll show 0. So if you don't have a stopwatch, right, it's with the questions coming in and all, you will actually lose track of time and you don't know how much time you have left. So my advice, the stopwatch thing is quite helpful. Certain mood competitions where they have a leeway for you to bring in your smartphone, then you can use your phone. But most competitions, they're quite strict. So usually we would bring in either the actual stopwatch, which I'm pretty sure your uni will have because they have sports day and all, right? So you can actually use those, or you can just buy a cheap hand wristwatch which has that stopwatch function. And once you have that function, right, to actually see how much time you have left, my advice is never exceed it. If you see that you're already about to run out of time, you should provide a summary of your arguments and then just conclude. Only because there's the danger where you eat up into your co-counsel's time, which I think is very possible, especially when you face a panel that has a lot of questions for you, right? So that's pretty much the structure for the A1. Then the A1 will pass it on to A2. A2 does not need to introduce everybody. He or she needs to introduce himself and then submit any of the same style. So then you go on to R1. Now, R1, you would need to introduce yourself and your co-agent. And if you, my advice is don't simply raise concerns with the summary of facts unless the summary of facts is really, really wrong, right? And it has to be really wrong, then you raise a problem. Because if it's something that's very simple, like maybe they missed out a point or two, just raise it up during your arguments. If you raise it up saying, Your Excellencies, we take issue with the summary of facts that was submitted by the learned counsel for the applicant because of A, B, and C, and A, B, and C are not good reasons, then the judges are going to feel that you're just wasting time, you see. So my advice is don't pick on the summary, just agree with the summary unless you have something really strong to say. So that's for R1. You introduce yourself, your co-agent, try not to go on the summary, just agree with it, and then immediately start on with what are the issues to be dealt with. So the format for R1 is a bit different because you don't start off by saying there are two issues. I'm going to deal with the two issues. My first issue is this. Instead of that, you are required to respond to the applicant's or the claimant's submission, right? So you would need to tell them at the very outset, look, this is what the applicants have said. I agree with this and I disagree with this. So you tell them which are the parts that you agree with, which are the parts that you disagree with. Now, this has a slightly psychological element to it. The reason why you want to tell the judges which part you agree on is because you don't want to portray to the judges that you're being very petty on everything. So we call it like it's sort of like picking your battles kind of thing. You don't need to fight on every single point. Can you imagine if, let's say, okay, let's say it's a Jessup's mood problem, and then applicant is saying, pursuant to the ICJ rules, this should be done. And then you want to just fight everything, and then you say the ICJ rules don't apply. I mean, of course they apply, right? It's given. It's like going to the Malaysian courts and saying the Contracts Act don't apply. I mean, they apply, but it's whether do they apply in your favor or not, right? So you don't need to fight on every point. And there will be certain things that you agree. How would you know which do you agree, which you don't agree? You pay attention to when they're speaking, or in preparation for the round, you go through their memorials. So usually you'll have a memorial exchange where you get your opponent's memorial, right? Some competitions don't do it. Like this, they don't do it. For previous, right, they never exchanged memorials, only because there were too many memorials. But Jessups and all, you do.
Mrs. Subash, can you hear us? I think you are stuck. We don't hear anything. Participants, please give us a moment to get our speaker to rejoin the workshop.
Hello.
Hello. Yes, we can hear
Hi.
you.
Sorry. I think it might have been my internet.
Yeah, all right.
Am I audible?
Yes, you are.
Okay. Great. Uh, Forgot what I was saying. Right. So
You
as
were,
I said, right, agreeing to which of the portions do you agree with and which you don't agree with. So I think it's important to tell the judge that. And you do, so for example, if there's a legal test that's going to be applicable, you don't need to disagree with the legal test because the applicant said it. You might be using the same legal test, and that is when you tell them that we agree with the test that's being put forth, but we disagree in the way that it's being applied. Right now, very important thing to keep in mind for R1 and R2: never say things that attacks the character of the applicant. Right, in this kind of discourse, in a moot court setting, or even in a courtroom, right, you never attack the person personally. So you never say things like the person is misguiding the court, the person is lying, the person conveniently left out this fact. See, all these certain mooters use it, certain judges use it in court as well, and they are fine with it. But if you ask me personally, I think you can argue or fight on a higher level. And what that means is you go after the points, you don't go after the person that's submitting the points, right? So you can say things like, this particular argument will not hold water because if it's in this situation, then it would not make sense. Therefore, our position would be the more practical one, right? Instead of saying, my learned friend seemed to have failed to consider these sort of circumstances. So essentially, A and B are saying the same thing, where practical wise, the applicant's arguments really don't make sense, but the way you deliver it really matters. And the general rule is always never go after the character of the person, right? So some teams will say some weird things, which I'm not really a fan of. Like there was one competition, they said something like, my arguments were soup without salt, and I didn't know what they meant by that. And the judges were just, so of course me being me, because I was young, not to say I'm so old now. So I was angry that they said that. So during rebuttals, I said something like, I submitted, I said, no, we don't agree. And then towards the end, right before I sat down, I said something like, I suppose it's good that we all reduce our salt intake, just to poke fun at them. But then it's useless banter, lah, you know what I mean? The judges enjoyed it, of course, because we were just like saying dumb things like that. But it's unnecessary, lah. So unless if they say it, then applicants you don't back down, but you don't attack their character. Also, you play a joke out of the statement itself, right? So you try to keep it on a high level in the sense that it's always arguments and discussions, not personal attacks, but stick to the format that these are the things that you agree and these are the things that you disagree. And once you tell the judge clearly these are the things that you disagree, then you go on to say why you disagree with them. So now the question that usually y'all might or would y'all would think about is, when do you do this? Do you do this as the respondent, right? When do you do it? Do you do it before your flag posting or do you do it after your flag posting? My advice is you introduce yourself and then you say you have how many submissions to make. So which means you flag post first. And then when you go into your each submission, you tell them this is what I agree, this is what I disagree, why I disagree, for two reasons. Your two reasons are essentially your arguments under your submissions, right? So I think that should be the format. Okay. And then you finish up your submissions, you conclude, you pass on the floor to your second respondent. Your second respondent does the same thing. Now, before I go into rebuttals and sir rebuttals, let me just get into a bit of just make one or two points on the crux of what you're going to say, right? So for applicant, sorry, this applies both to applicant and respondent. When you formulate the arguments, right? Um, because I've not gone through the moot problem in detail, so I will not be able to tell you all what should each mooter say or what. But I think it's very important that y'all pay attention to the types of authorities that y'all cite. Now, a very basic advice would be to check your sources. So definitely you don't want to have situations where you're relying on, let's say, Wikipedia or something like that. And people think this is funny because they are very confident they'll never go to Wikipedia, but then they do other things like rely on blog posts and all. So you must be very careful on the types of sources that you're relying on. Then comes the big question on which sources can I rely on. So usually, first year law students, or in fact, pre-U, when you do law, right, you would study things, chapters like judicial precedent, statutory interpretation. So these chapters will tell you in a domestic setting, what are the authorities that you can rely on. If you have one mooter coming and submitting on a blog post and basing his or her arguments on positions taken by the writer of that particular that blogger, right? And then you have a second mooter coming and telling you there's a court of appeal decision which says this, and they base their argument. Definitely, you're going to buy the court of appeal argument, right? Only because it's more authoritative. So the doctrine of precedence will actually dictate to you on which authorities are more persuasive. And that's the fun part, because when you learn about it, you only learn about it in the aspect of, oh, the federal court can do this, the high court cannot do this, and then you learn Bristol against aeroplane. So this kind of very theoretical um, do's and don'ts on what a court on how a court functions, right? Like you will not have a situation where a high court rules, bar a few exceptions, of course. You will never have a situation where a high court expressly rules against a previous court of appeal or federal court decision, right? Only because in the court structure they are not they are not of an equal standing to make such a ruling. So similarly, you will know that when you have a moot problem that requires you to argue before the high court, citing a lot of court of appeal and federal court cases would be very good for your argument because they are binding authorities, right? Then comes the advice that I have for international law related moot problems because they don't have such a court structure. And you, in fact, have the ICJ statute having provisions which says that they don't abide by precedents. All previous cases that they have decided on are merely persuasive in nature. So then you have an issue because now you have all these various different jurisdictions that you can take up cases from. The ICJ is not bound by its previous decision. So then what is binding authority? So my advice is, I think the key which I usually advise mooters, particularly doing moot competitions with international law, is to always start with Article 38 of the ICJ statute. Because Article 38 will sort of list out for you the basic um, legal documents where you can get principles from. So you will have treaties ranking and one of the highest, followed by general principles of international law. And then it'll have this very weird phrasing, if I can recall correctly, something to do with established principles by states and whatnot. So Article 38 sort of gives you a rough idea on what the judges would feel comfortable to deal with, right? As opposed to a blog post, you will realize that it's better for you to rely on treaties between the parties for you to forward a particular argument, and that stands a stronger chance of persuading the judges. And you can use this against the opponent also. So for example, right, if you have an academic, if you raise a provision in the treaty between the countries, and then you say that there's a breach in this treaty provision, and your opponent raises an academic opinion saying that this academician said it shouldn't be this way, during your rebuttals, you can always say that, look, in terms of persuasiveness, the treaty ranks higher, and therefore this argument is of a higher persuasive value, right? So that's one way that you can sort of launch an attack against the opponent and solidify your arguments, right? So just be careful on when y'all take the arguments on the types of authorities that y'all really sort of rely on. Use 38 as a guiding force. So the most confusing provision, I think, is when they say things like taking authorities from established jurisdictions. So there's a lot of debate on what do they mean by established jurisdictions. Usually the advice that I would give is to take two maybe prominent common law system cases and then civil law system cases, and then say that this principle is prevalent in both these jurisdictions, both these types of legal systems, actually. So that's an example on how you use 38 to your advantage. The second point that I want to make is when you play the role of the respondent, try not to disagree or point flaws with cases too much. Maybe you can distinguish those cases, but especially for your rebuttals and serve rebuttals, right? I think it's a waste if you say that, oh, the opponents relied on this case and this case doesn't say this. The danger with that is because if you say that for rebuttals, for serve rebuttals, your opponent can just say, oh, okay, I see my learned friend takes issue with this case. I have three other cases to support my point. You see, so it's a very I think it's a very mediocre way of responding. My advice is, instead of picking on the cases that the opponent have relied on, it would be best for you to go after the arguments proper. So what I mean by this is instead of attacking a case on offer and acceptance in the contract example, you can actually say that the elements of offer is not fulfilled and why and how they have misconstrued that particular element. And then you can make a statement on the case. So as a general rule, when you're always engaging on the offense, right, like you're trying to pick flaws with the opponent's arguments, keep the case laws to a minimal first. Go after the larger points, and then as one or two liner you can address the cases that they've relied on. So this is something maybe to keep in mind when you all are trying to phrase your rebuttals and sir rebuttals. And that pretty much sums up the whole round. So after you have the rebuttals, sir rebuttals, you would usually have the judges going in to deliberate, and then you'd usually have the comments section. I just want to raise one very weird thing about the order. So I'm pretty sure everybody is familiar with the order. It's A1, A2, R1, R2, and then either A1 or A2 gets to do the rebuttals, and then R1 or R2, either one of them does the sir rebuttals. But the order, right, gets really confusing for certain types of competitions, especially for this. The reason for this is because you will have certain competitions where, even though you are the respondent, you are raising an objection. So, because you are raising an objection, you are required to show that you're required to establish it. So, to put things in perspective, right, you have an arbitration going on. The claimant is sort of, to very loosely say it, suing the respondent. But the respondent is saying the tribunal has no standing, has no jurisdiction to hear the case. So it doesn't really make sense for A1 or C1 in that case to start first. Because C1 is considered like the respondent, if you think about it, right? Because respondent is saying they have no jurisdiction. So if let's say I'm the claimant, when I start, what am I going to say? They have jurisdiction. And what am I supposed to cover all the 100 different reasons why they have jurisdiction? It doesn't make sense. So for this, right, you'll realize what happens is the order is like this. It's R1 followed by A1 and then A2 and then R2. Gets very confusing, but the reason is because whoever that's putting forth a proposition like the tribunal does not have jurisdiction starts first. So only in very rare situations you will see the order getting mixed up a bit, and it usually happens for this. Right? How it happens is before the judges come in, the opponents will talk to you and they'll ask you, "Are you okay if we do it this way?" And usually, if you would agree, if you don't agree, then when the judges come in, they will raise it up as a procedural objection. They will say, I propose to the applicants that we should start first, but they disagree. Can we have the judges decide on this? And then the judges will decide. But for competitions like Jessups and all, it's very standard. So my advice is don't try to shake things up a bit. And if somebody wants to shake things up, I would suggest you don't do it because you have not trained for that, right? So it's sort of it's unexpected, but have good reasons why it shouldn't be done that way. Especially for competitions like Jessups, very rarely do you have those kind of situations, right? So that is just something to think about. The other thing that usually concerns a lot of coaches, or in this situation, if you're a team without a coach, right, is this whole role of an anchor. How is it that you assign the role of an anchor to someone, and when is it that you don't need an anchor? So, in my opinion, if you have a team which comprises of members that are equally good, then I really don't think you need an anchor. The anchor is a person that does both sides, and usually the anchor would be the person that's the most senior in the team, or even if the person is not the most senior, the person is the most well versed because he or she is able to switch sides and they are very good with their own position because it's double the work if you think about it. Right? If let's say a mooter is expected to work 4 hours a day, the anchor pretty much works 8 hours a day. It's there's actually no way of going about it. It's really double the work. You present twice, you take twice the time to prepare, you draft more materials twice. So it's two times the work. So you usually give it to a person that's well equipped to handle it. For a coach, it is a strategic decision. The reason for this is because you have this thing in mood competitions where they call it, so there's ways to measure, right, which team makes it to the next round, which who is the best mooter. The way to do it is they have this thing called raw scores and this thing called round points. So what are raw scores? So each of y'all are given over 100, right? So if you look at the rules, you will see there's 20 allocation for knowledge, 20 for analysis, extent and use of research, clarity, style. So that's 5 times 20, 100. So whatever marks you get over 100 is your raw scores, because it's just that. It's raw in that sense. There's no dividing or multiplying, right? So usually your raw scores will be an accumulation. So each team, if you think about it, because there's only two speakers per round, is given 200 raw scores, right? So if you get, let's say, 50, your co-agent gets 50. 50 is really bad, by the way. If let's say you get 50, your co-agent gets 50, then you get 100 over 200. 100 is your raw scores for that round. But you also have this thing called round points. So what are round points? Round points is usually points that you allocate to the team that wins the whole competition. Now, what are situations in which the raw scores can be different from the round points is when you have, let's say, one mooter, let's say A1, right, does so well that A1 gets 99, and then A2 gets 50, R1 gets, let's say, 80, R2 gets 80. So in terms of raw scores, A1 usually takes the lead because A1 is in running for the best mooter award. But overall, the round points would be allocated to the respondent, because if you add it up together, the respondent ends up winning the round. So you would usually give them the round. So then comes in the role of the anchor. So usually why they would want to have an anchor is because the best mooter award, usually, right, there may be exceptions for this, is calculated based on raw scores. That means over 100 for each round, how many points did you get? So if I have a team where I know one person is really good at this, and that person I think should have a good chance at the best mooter award, I would make that person the anchor, because I want that person to go into as many rounds as possible and accumulate the raw scores. So how they do it is, if let's say now there's so this competition, I think there's prelims and then there's finals, right? So assuming there's two prelims, example, right? So total you'll have 3 rounds. If let's say you make it up all the way to the finals, I know there are two separate best mooter awards, but to keep things simple for explanation reasons, let's assume there's 3 rounds in total. If let's say you're an anchor, confirm you'll be doing all 3 rounds, right? So what they'll do is they'll add up your raw scores and they'll divide it by 3. In other words, they'll average it. And if you're not anchoring, let's say first round your team gets applicant, second round your team gets respondent, third round your team gets applicant. So let's say you're not anchoring, you're a respondent mooter. You only have 1 round, and then they'll average it, of course. So it's divided by 1. So let's say for that round you get 70. Your raw scores is 70. You run the risk, you see, because if you have a panel that's very stingy in terms of avoiding points, then you might be the best mooter there is, but you risk that round because you only moot one time and then you get 70. But if you're an anchor, you get to do more rounds. So even if you face a panel that's very stingy with points, you know you can try to make it up in terms of score for your next round. And when it comes to an averaging, the damage isn't so bad. So it's a very strategic thing on why you would need an anchor, because usually you would put the person that you feel has the best chance to get the best mooter award. So you want that person to enter as many rounds he or she can, so that when they average the points, it's very high. It's not like putting all eggs in one basket. There's only one round that person is going to moot. If that person gets a tough panel, gone, right? So this is a decision that's usually left to the leader of the team or the coach or the lecturer, whichever the case may be. But if let's say it's an internal competition like this, then you would want to discuss things like by consensus who the team thinks should be the anchor. And I know the competition is not so far away, but decisions to become anchor and all can be done quite last minute. I've had experiences like that. And we have done some while anchoring. What I mean by that is, so the traditional way to do it is, let's say if I'm an A1 speaker, then I do R1 because it's the same points. I just prepare it for both sides. But I have been in a competition. This was for the ALSA Moots where we represented Malaysia in Sri Lanka, where I was the anchor, and I had to do A1 and R2, which was crazy because I ended up preparing like for all 4 points. But it was fun. It was a good experience. The only reason we did that was not because I wanted to do it, is because our R2 speaker dropped out last minute. So I had to take over. This kind of quitting thing is quite common. So the person dropped out and then I had to take over. So it was like a cross anchor thing. Um, some teams, right, like if you notice for Jessups, they will do things like this. They will wait and see who's the opponent, and then they will put in a motor for that opponent. Because Jessups, you have 5 people per team, 5 students per team. At one time, each round, you only have 2 students presenting. So you can choose who do you want to present for that round. So they will most probably have a final year student that's very good, certain teams, right? And then they will only reserve that person for when they go up against stronger opponents. For me, it's very simple. I don't do that kind of things because I think it's very confusing for the motors because they don't know when they're going to mode, when they're not going to mode. It's very, I think a bit of certainty is good, especially during stressful situations like the mood competition day. So when I trained the Jessups team or any other teams that I've helped out with, usually it's very set. Like this person does this person does this person is a researcher. That's it. And they're all happy with their roles. Like I've never faced a situation where the mooter is unhappy because we usually we're very frank and we decide it on the best interest of the team. So that's pretty much my opinion on the anchoring part and maybe how y'all can utilize it for uh, team strategy. And that sort of brings me to the end of what I want to say. If y'all have any questions, I'll be happy to take them. Thank you.
So, should we move on to the Q&A session?
Yes, we can.
All right. Okay. So we have a few questions that were sent to us through WhatsApp. Like, let me just read it out for you. Before that, does anyone want to turn on their mics and ask a question? Okay, so we have a question here. They asked what to ask the judge for extension of time. How do you ask the judges?
Right. So the theory part of it, the theory part of it is you when do you ask it? I think is also an important part. So I'll address that first. So you would usually ask the judge for an extension of time when you know you have been asked a lot of questions. That's the only time you have proper standing to ask an extension. Because if you don't have a lot of questions, you have maybe 2 questions. Okay, I'll just be clear. What I mean by a lot of questions, I think is anything beyond 4 questions. Because if it's below 4 questions, I think you should be equipped to handle them, right? If you have, let's say, 2 questions and you ask for an extension, you're definitely going to get marked down for time management, which is not a criteria spelled out for this competition, but for Law Asia, it is. Time management is actually a separate criteria, and there's 5 marks for that, which I think is valuable. So, why is it that your marks are going to be at a detriment if you ask for time when you don't get enough questions? Is because they will know that when you prepared you didn't take into account this factor that you will get 1 or 2 questions, or they will feel like you didn't train enough, like you didn't time yourself when you train, so therefore you have time management issues, right? So I think it's okay for you to ask for time if you know you have received more than 4 questions and you took sufficient amount of time to address each question. So that's theory part on when you should do it. How you should do it, you will just say, so let's say now you're within your 1 minute in your stopwatch, right? Or maybe the timekeeper shows up, it's 1 minute left. Never ask for time until you run out of time, right? So just because you see that you have 1 minute left, you don't say things like, I see that my time is almost up. You don't need to do that. Just finish up your time first, then you ask for an extension. So you wait until the zero time placard comes up, or you wait until your stopwatch shows you that it's zero, and then you can tell, because it's a Jessup's style competition, because it's ICJ setting, right? I would usually say, Your Excellencies, I see that my time is up. If I may kindly request for an additional half a minute to summarize my points. So never ask for an extension of time more than 1 minute. Some guys go crazy. They will ask for an extension of time for 3 minutes, 5 minutes. It'll look really bad. Only because in the moot court setting, right? It's it really shows that you're not able to summarize your points fast. But in a practical setting, the organizers have already put pressure on the judges to finish the round at a certain time. So then it clearly shows that you're disrupting that instruction, right? So I would usually ask half a minute just to summarize it, right? And the way I would do it is like that. Your Excellencies, I see that my time is up. If I may request for an additional half a minute to summarize my points. I hope that answers the question.
All right, so do we have any more questions?
Hi, can
Hi.
you hear me?
Yes, we
Yes.
can.
So I want to ask a question about so I noticed that you were the coach for BSc student for the national round at Jessup, right?
Yes.
So I saw that they have really done well in their oral submission the last time at national round. So I want to ask about the strategies, or what do you have like in training for them to reach that level, because one of them actually won oral, I think best oralist, right? So yeah,
Yes.
so what are the strategies or training that you have them to do? That's all from me.
Mm. Okay, so I'll just address the best oralist. So the best oralist was Shu Huan. Yeah, amazing mooter, but I never gave her any extra uh, attention, right? I think because I think for the last session or what, they spoke, right, some of the mooters, two or three of them, I'm not sure. So they would be able to attest to it. I never gave priority to one single mooter. Ever since when I was mooting also, I was always of the position to give opportunity and to look out for the younger mooters. The reason for that is because when I joined mooting, right, it was during my A levels. So I was always the slowest one to catch up. And I was very appreciative of my seniors who actually ended up looking out for me. Right. So that is why I'm of the opinion that just because I feel there's a senior in the team, I wouldn't spend more time for that senior. But a lot of coaches do it and they are not wrong in doing it. I don't think there's anything wrong in doing things like that, only because your job as a coach is to win, right? Whatever said and done, team spirit, it's for fun, it's a learning process, yes, for the mooters. But if you're a coach, then you're supposed to make them win. So, of course, if you have a good team player, you're going to put in more time for that person because, like I spoke about how anchoring works, that person might be able to have a good chance. But that was not the strategy for Jessups. Everybody got equal time. So to go into specifics a bit, the mood problem came out around August, September. January, mid-January was the deadline for memorials. March, February, March. I think March was the competition, nationals. No, no, February. I think end February was the nationals. So how we divided work was for the UOL people. They will usually have exams in May, June, and they will have exams in October. So I think, if I can recall properly, two of the Mooters were having exams in October. So which means they had to tone it down a bit, at least until October. But it was a bit risky because we know the other teams will be spending a lot of time on it. So how we did it was the mood problem came out in August, September, right? The moment the mood problem came out, what we did, we read through the mood problem, and during our training sessions, we would read the mood problem together, not line by line, but we would read in our own time, but we would discuss each paragraph and portions of it. Like, what does it mean? What are the important parts? Right? The thing about that, so let me just also say the structure of the training, right? So August right up till no August, September, October, November, right until November, the agreement we had was Thursdays, Fridays, Saturdays, Sunday, our training would be 7 to 12 at night, uh, online. So it's 7 to 12 at night. After November, it became havoc. We were meeting up on Mondays, Tuesdays, every other day. Saturdays, we will spend a whole day. So, yeah, towards the end, of course, uh, this was all foreseeable. Like I told them it's going to happen, and they were fine with it. They really did that in that sense. But generally, if you ask me, because once we pass up the memorials, we had a bit of a break. Like we didn't go intense and all for about a week. But either ways, the consensus was every Thursday, Friday, Saturday, Sunday. Sorry, was it Wednesday also? I forgot. I remember. I think it might be Wednesday also. Wednesday, Thursday, Friday, Saturday, Sunday, 7 o'clock because it would be after work for me. Right up to 12 would be the training session. Sometimes, actually most times, it might even go up to 1 or 2. Only because there were things that we needed to get done, right? So that is the schedule. Like towards the competition, it got a bit more intense, but it wasn't so intense like as if Monday to Friday full day because I was working, right? So I couldn't like just take off. And then this is a competition that ran for a span of 6 months, almost half a year if you count it like from June, July, the whole uh, what do you call it? Main points of the mood problem will get released, and then the mood problem comes out. So it's a very long stretch. It's like a marathon. So we cannot like train every day because we'll get worn out by the end. So in terms of scheduling, that's the strategy we took. So when the mood problem came out, the first thing that we did was we spent every day just looking through the facts of the mood problem. And what we did for fun was to take a break because the sessions are very long, right? And we are all expected to have dinner before the session. So it's not like we take a break during the session. It just goes on. And it gets boring if you just read the mood problem without doing anything. So by the side, we would spend maybe the last final hour of the session. We would prepare maybe the front cover of our memorial. We'll all prepare together. Lah. Like one person will share screen, then I will say, no, I think this format is not right. This format is not right. So we will prepare the front cover, and then we will prepare prayer of relief because prayer of relief all it's in the mood problem, so you will know what to put in there. And then we would prepare so once we prepared the front cover, prayer relief, then we prepared there's this thing called jurisdiction. There's a separate portion which in the memorial which will say that the ICJ has jurisdiction over the dispute. So we prepared that because that didn't require any research. Then we also prepared so that sort of took us about 2 weeks, right? Just reading the mood problem, taking our time going through the formatting, preparing the cover, looking through at different memorials. So that took us about 2 weeks, doing some minor research on the mood problem. Then once that 2 weeks has gone, we took about at least another 2 weeks where we spent every day starting to draft up the summary of facts. Because in your memorial, you must do a summary of facts. So the idea was if we all did the summary of facts together, like I said, one person will share screen and I'll delegate it. Depends on who does what. right? So one person will share screen and we will discuss like, okay, this should be the first paragraph on how the summary of facts should be. So when we do that, we once again refresh ourselves with the mood problem, right? So that took about 2 weeks. So by the end of the first month of training, we actually had our summary of facts. We had a rough idea on what arguments to take, but we were very well versed with the facts already, only because we have been discussing it almost every session, right? So we really took our time with the facts. So 1 month, right, which means 4 weeks. At the last week of that month, right, the first month, we started figuring out what are things that we wish we had gotten from the facts. We wish that we feel that it's incomplete facts. So everybody made a list. I made my list. The other 5 members made their own list. Then, when we begin the new month, what we did was we all compared the list because now we are going to sit down and do the questions that we're going to ask for clarification. So, for Jessups, you're allowed to ask 5 questions of clarification. And we took it seriously. We really wanted to make sure that whatever we ask actually gets answered. To be very frank, in retrospect, out of 5 questions we asked, I think 2 got answered, which is bad. But I mean, it's okay if you think about like how many teams are hundreds of teams are joining. At least 2 got answered, right? So in that sense, we were quite happy. So what we did was we compared it wasn't proper questions, but just things that we wish we knew to help that position, right? So we got all of the list, and then we spent a whole few sessions comparing the list. So we feel maybe we should ask this, we should ask that, we should ask this, we should ask that. Right. Then we put the list aside because we feel, or rather we felt, that that list wouldn't be complete if we don't have some groundwork research done first. It's good to have some idea, like just on the facts alone, what you feel is missing. But when you study the legal test that's to be applicable, then you'll realize, oh, there's actually other things that we can ask for clarification, which maybe if they answer, it will be a good point to support a case. So we had that rough list, right? We kept that aside. Then we spent at least a month on each role, and we don't delegate the role because the way I see it is everybody brings in a different perspective to the discussion. So we spent 1 week just on A1, 1 week just on A2, 1 week on R1, 1 week on R2. In total, right, it took us about at least 2 months to do that, right? The reason is because sorry, it took us about 1 month because each week we will have 4 days of training. The reason is because we didn't approach it according to speaker, we approach it according to issues. So there's 4 issues, 2 issues per speaker. So which means in total everybody has to do 8 issues, 4 in the perspective of the applicant, 4 from the perspective of the respondent. So everybody researched on the spot during that training session. Like I would say, can you all please brief me on this? Then they would brief, and then they would tell me what is it about. So what is the guiding list? Because there's so many things all over the place, right? Like we could read pretty much any textbook and it would be helpful. To limit that, what we did was once we finished up our first month, right, we actually had a session where we looked through the recommended reading list released by ILSA, and we divided that reading list. So we had 2 juniors in the team, 3 seniors because they've done competition. What I did was I paired them up with sort of like 2 seniors, 1 junior, and then 1 senior, 1 junior, that kind of arrangement. And we divided up the list. So, of course, I didn't take any part of the list because I didn't have time. Also, I shouldn't be reading it because it's their work. So but I overlooked the part on who is taking what role to make sure they don't get overburdened, right? Because one team will have 3 people, but there's only 5 of them. So you have team A, which only has 2, team B, which has 3. Out of which, what I did was I allocated the October exam people separately. That means it's not like team B has all the October guys there. They were allocated equally. So I know that everybody moves at the same pace. So that was done, and then we divided up that list. So every week, what happens is they are supposed to brief me on what that document is. So that list will have different types of document. You'll have some rando documents like ICJ statute and all that. So they're supposed to tell me, okay, this is the document. They don't need to tell me each article or each sentence what do they mean, because that's just too time consuming. Some of the documents are really thick and it doesn't make sense. They're just supposed to give me a brief on what that document is, what how parts of that document can support any of the four issues. So last time I used to refer to them as 8 issues, because it's actually 4 issues but different two sides, like I said, right? So we used to run through that whole list. And when we finished that list, we realized we had a rough idea on what each side or each speaker is going to say. Then we were ready to look back at our set of questions or concerns that we had for the clarifications, because we already knew, we had a clearer picture on what was going on, right? And we looked back, fair enough, we had like additional, like at least 15 other questions. So we spent 1 or 2 sessions finalizing those questions. And at the end, we cut 15 questions to 8 questions. Then what I said, I told them, at the end of the day, I'm just a coach. It is your competition. So what I'm going to do is I'm going to completely leave it up to y'all on out of the 8, which 5 should go in. So I didn't come for one of the sessions. I told them to handle it by themselves. So they had a meeting among themselves. I don't know what they did, whether it was voting or what. I just wanted the 5 best, because, and I wanted them to have the freedom to pick. So they picked the 5 best and then they sent it off. And then what we did was, because now we already have the clarifications out, we have already sent it out, we already have gone through the reading materials. Now we allocated roles. So each mooter, which role they will be doing. So how I did that was, because I don't like things like internal conflict, like they're not happy, but then they're doing a certain role. So first I said, can you all individually just WhatsApp to me which role you all would prefer? There was some general ground, like one of them said, I don't want this role. One of them said, I want this role. So there were very little conflict because I told them to give first option, second option. So we came with an arrangement where everyone was happy, right? And we never flipped that arrangement, right? So everyone was happy. And then what we did was they started researching on their respective roles. And during the sessions, I will not hear them speak first. We will start drafting the memorial and we will draft all together one. So for example, right, let's say Stanley is handling first applicant, although he's researching for first applicant, when it comes to the meeting, which is Wednesday, Thursday, Friday, Saturday, Sunday, right, the evenings I spoke about, during that meeting, I'm not going to hear out Stanley alone, because if I hear out Stanley, then I don't, I'm not spending the time for the others, right? So what I do is I ask Stanley to present what he has. He will Google share his empty page, and he'll start typing out what he's going to put in for the memorial, and all of us will give our input. So during that time, I feel we need a case for this. Stanley doesn't have to look for it because Stanley is already handling the typing one. So another mooter will help out with the research. So that is how I make sure that each portion of the memorial is a collective effort of 6 people, including mine, whichever input I can give. Right? So once the memorial is done, only then I gave them 1 week to rest. But of course, I was scamming them because I told them 1 week y'all can rest. But when we come back, I want to see the script. So it's pretty much not rest. They were working on the script. It's a scam. So they really continued working. After we submitted the memorial, so we're talking about mid-Jan, was when I actually saw their scripts for the first time. So the rule is I will not see their scripts first. I will hear them submit. So like I said, because I have limited time, right, I don't want to concentrate on one mooter solely. So what I did was for each session, I would hear them per team. Like maybe applicant team, I hear y'all first. Respondent team, I'll hear y'all another day. Then what I did was I discovered that some of them had certain areas they want to improve on. So I said, look, the competition is coming near. I give you all full leeway to ask me a private training session anytime you all want, except for 8 to 5. So there were a lot of days, right, where out of their own initiative, right, they will ask me for, because I'm the person that goes into the office very early. So I will have a session with them. Let's say there was a few times in a week I was having 6:30 to 8:30 in the morning, and then evening will be our normal session. So they have extra sessions like that with me, only me and them individually. And I would say at the end of the day, right, everybody got an equal allocation, right? So that is going on. I dedicated one whole weekend, which means Saturday and Sunday, and it was a full day only for rebuttals and sir rebuttals. We already decided who is going to do the rebuttals, who's going to do the sir rebuttals. So we had a week to prepare. So that was at the mid of January. Early February, right? First week of February, we started calling in guest judges. So what are guest judges? Guest judges are just practitioners or people that are good in mooting, who will come in and sit in as a judge. So we had a few sessions online, we had a few sessions in person. So we had it in BAC. The judge would actually come in, lawyers, seniors, people that I've worked with, people that the mooters have interned with. They would just come in and hear them out, ask questions, give comments. That happened from February until the competition, 1 week before the competition. Because the rule is the last week of the competition, we usually relax because that's where we print everything, highlight everything. We don't want to have any new points coming in already. Um, so the guest judging sessions were going on. Now, 2 weeks before the competition, the memorial exchange and all happened. So we spent at least a week solid just to read through the opponent's memorial and discuss point by point on what are we going to respond to if they raise this, if they raise that, right? And we discuss it as a team one. Like I will never, let's say Shu one is R1, right? I will never discuss the applicant's opponent applicant's memorial with Shu one alone. When I look at the applicant's memorial, I will discuss it with everyone so that everybody can give in their input on how best to come up with a response. So when that was done, effectively we are done with memorial has been submitted. We have already dissected the opponent's memorial. We have already gone through. So total, I think we had 12 guest judges. Certain rounds you'll have two guest judges, certain rounds you'll have one, but we had a total of 12 different people that came in. I think so. Was it 12 or 10, around that number? So we were done with the guest judges. So we had a final week left. That week, I never met them for anything substantive. I was just there to, we met up at the BAC campus because we needed the printer and all. I was just helping them, like making sure everything is highlighted, everything is tabbed. That's it. On the day of the competition, I remember we all stayed because it's in UKM Bangi, right? On the night of the competition, the idea is everybody goes to sleep at 11. Of course, I have to be there because some will try to be funny, right? They will try to stay up late and all that. But that whole night, no, I don't ask them any questions anymore because it's too near to the competition. So it's just a matter of filing everything up. So that's pretty much the whole strategy. If you want me to boil it down to broad areas, it would first be analyzing the mood problem, coming up with going through the reading materials, finalizing clarification questions, finalizing memorial, script, guest judging session, printing out materials. That's how I would summarize it. Yeah, I hope that answers the question.
Thank you so much. So, would you like to answer a few more questions?
Sure, sure.
Okay, all right. So, someone asked, should you include facts that kill your case in the summary of facts?
Should you include facts that kill your case? Yeah, I mean, if it's an agreed fact, it should be there. So there's two ways to think about it. There are many writings on this where they say that to sound more convincing, right, is not to hide what's weakest in the set of facts that you have, but is to bring it out at the open and tell the judge, look, this is the fact. It's not really looking good for me, but this is my response to it. That way, it shows the judge you're a very credible person because you're somebody that's willing to think on a higher level and not resort to these type of tactics, sweeping it under the rug and trying to see if the judge might know or catch. You're able to say these are some of the weak points, but I have an answer to them, and these are my answers. Because if you sweep it under the rug, you also run the risk that the opponent might bring it up, you see. And then you have very little time for damage control when it comes to rebuttals. So, my advice would be to always bring it up and then find an answer to it. There will always be an answer, I think. Yeah.
Right. Okay, another question is, what advice do you have for participants who struggle with nervousness or stage fright?
I really do think stage fright is only the first few minutes because once you start, right, and you're into your submissions proper, I think it really goes away. Like you forget about it because there's just too many other things to get done, especially when you get questions, right? I've if you're well prepared for it, I really think when you face a question, you're just eager to answer it. So you're not really in the position of being afraid and all. But there are ways to curb that problem. I think this kind of advice, like imagine the judges naked, that kind of thing, I think it's very amateur kind of advice. For me, if you ask me, if you actually think about it, right, this whole nervousness thing usually comes in because you feel that you might not be able to answer certain questions. And you feel things like because of that, you're going to get scored low, and then you might disappoint your co counsel because that person has worked hard. But the only way to circumvent this is for you to actually research hard because you have to remember, especially for jessups, it's quite motivating for you to do this because you know for a fact that these judges do not encounter public international law on a daily basis. So that means that if you research every day, it's actually true that you will know more than the judge. But the same doesn't go for Kelba and all, because they do that every day. So no way you will know more than them. All you need to show is you are worthy to have a debate with them, which means you know enough. Here, you actually have a standing chance to know more than them. So I think that should be a confident booster because at the end of the day, if you put in the work, right, which is not too late, I think there's more than a week more, right, for the competition. Yeah, so it can be done. You you can take comfort in the fact that any questions that they asked, even if you're not able to assist them, it's fine because you know that you have covered the relevant points, you see. So I think that's something that usually gets rid of the fright for me. KL bar was something that I was very nervous because I knew that public university students, they study Malaysian law. Like University of London, we study UK law. So I knew that the opponents would be very good. But we just put in the hard work to make sure that we covered all angles. And the guest judging sessions are very helpful because that will give you a rough idea on how the questions are going to come. So usually, I mean, if you have gone through like 10 guest judging sessions, it becomes a bit normal for you because you've already done it a few times. So that's one way to get rid of the nervousness. So I think preparation in terms of the amount of research that goes in, only because this is a Jessup style competition. So it involves an area of law that's not very common. That's one, the research. And the second is the guest judging sessions would help. I think these are, if you think about it, this could really make an effect on how you feel during the round. Yeah.
Okay, so one last question. What are some common mistakes that you have observed among participants in their oral submission?
Common mistakes. So some of the ones that come to mind is very basic ones, which can have very bad impact, is to mix up the gender of the judge. Because I've been in a round where my learned sister, of course, was a female, is a female. So one of them called her my lord, and then this is recorded, right? Is it live screen in Facebook? No, right? Is it?
No, it's not live streaming, but it
Okay,
is
great.
recorded.
So she
Mhm.
decided to be a bitch about it. I mean, I've told her about it. So, and then she just went on a rant, like she said things like, Oh, you think I'm a guy, is it? I don't want to hear what you're saying. So this kind of crap all happens, lah. I mean, she's a very good friend of mine, and we laugh about it, but pity the mutta lah, So she didn't hear him, until the end. Like she just said, I don't want to hear you. And then she just looked outside the window. I still remember. So, and she was chair, which made it quite bad. Lah. So, I think that's one common mistake that usually happens. But for competitions like this, only because he was nervous, by the way, by no way does she resemble a man, in case if that was a concern. So, I think competitions like this is slightly better because you have your excellencies, right? You don't call them my lord, my lady. But that's one common mistake that I hope um, it's very easy to do because you're just nervous, but some judges might take an issue with it. Other things, right, is when you call them you. Because sometimes you are just exchanging answers and questions. Like you answer something, the judge asks something, and then you answer something. Then suddenly you say things like, I hope that answers your question. They will take great offense to it. Like you should never refer to the bench as you, your, right? So you will want to rephrase that by saying, I trust that that answer I trust that that answers my Lord's question, right? You wouldn't say your question. Sometimes you do it so fast because you are nervous or you want to finish up a point, but then they actually take a lot of offense to it. So that's another common problem. So that's a bit more on the advocacy side. A bit on the substance would be they will test you on the facts of the authorities that you're citing, right? So, for example, if you say you want to cite Nicaragua, right? They will ask you what happened in Nicaragua. So then you would need to know some of the basic facts, right? So it's very important for you to know the facts. Some of them will go deeper. Like let's say you want to talk about dissenting opinions to do with use of force. They will ask you who are the judges that comprised of the majority and who was the dissenting. So you need to know the judges names also. So my advice is always have a table. That table at the most left hand side of the column should be your number, obviously, because the table. Then followed by the number will be your cases, which should be arranged which should be arranged alphabetically. So it's very easy to look for it when you need it to be quick. And then beside the case name would be your summary of facts, the judges, right? So if you have this document, it's easy. And I think this question usually traps a lot of mooters because if you don't know, you cannot lie. Some of them will try to lie and then they get caught. When they get caught, it's bad. Yeah, so this is another common problem. That's a bit more on the substance, I think. The other issue that which is more geared towards, I suppose, experienced mooters, is maybe you might miss out certain cues that the judges are giving. So for example, if you're applicant and then for the respondent you hear them question the respondent on point A, but then they are pretty okay with point B. Very amateur mooters, right, will think to themselves, oh, the judges were happy with point B, so I have to attack point B. But I think it's actually the opposite. Because the judges had problem with point A, for rebuttals, you just attack on point A. That's the best thing you can do. What? And you know the opponent has nothing to cover up already because they already had a hard time. So maybe this is something to look out for. Meaning that the third thing being that see how the judges respond to your submissions, see how the judges respond to the opponent's submission, right? A fourth thing, which I'll just stop at there because it's very long. So the fourth thing is when you refer to documents, I notice some of them have weird ways of referring to it. Like it'll be a 20-page Moot problem. They'll say it's paragraph 2, line 1, and then I have to find where is it. So imagine you have a stack of documents. Always refer the judges the way you would logically do it. So in the stack of documents, you would first want to tell the judge, I'm going to refer, or I refer this honorable court to the Moot problem or to the memorial or to the clarification. So you tell them which document first, followed by the page, followed by the paragraph, followed by the sentence. If you mix up the order, it's a bit weird. They'll, like, for me, I'll get confused. Like if you tell me page 6, paragraph 24 of the Moot problem. So when you say page 6, I'm still looking at you because I don't know which document it is. But if you follow this order, it's pretty clear because it's very instructive. So that's maybe one minor thing for you to keep in mind. Yeah.
All right. Thank you so much. So with that, we will wrap up the Q&A session here. Now I invite all the attendees to turn on their cameras to join our guest speaker for a group photo. Can I know, is Ethan the one taking the photo? Yusuf, can you take a photo?
Yeah, sure.
All right.
So with my count, everyone's ready?
Yes.
Seems like not everyone. Okay, turn on the camera. Okay, so yeah, I'm waiting for everyone to be totally ready. Okay, all right. So wait. Adiba seems like she's struggling. Okay,
Okay.
okay, all right. So 1, 2, 3, ready. Okay, one more. 1, 2. Okay, one more. All right. Okay, nice. Okay, thank you.
Thank you so much, Yusuf.
Yeah, sure.
Okay, so unfortunately, we have come to the end of our session. Thank you so much, Mr. Subhash, for spending your time with us.
Thank you.
Thank you to the attendees who are here today. And on behalf of the organizing committee, I would like to apologize for any shortcomings or inconvenience caused throughout this entire session. With that, I end my duty as the MC. And thank you, everybody, and have a great day.
Thanks. Thank you.
All right, thank you, Mr. Subhash. Bye bye.